Copyright, moral rights, and Warcraft III Reforged. A legal look at Blizzard's new modding policy. Hello and welcome to a new episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today we are once again looking at the world of end-user license agreements, or in this case, an ancillary referred to agreement that is added on to the end user license agreement that is affecting one of the newly launched games from Blizzard. Now, as you may have noted from the title of this video, this is not a part of the Blizzard of Backlash series, which focused primarily on the issues that Blizzard had with its banning of Blitzchung from Hearthstone play and the reactions of China and the world to those particular acts. This is about Blizzard, this is about a game that they have produced, but it's not about China, it's not about censorship or any of those kinds of issues, so that's the reason you're not finding it in that specific playlist. Instead, what we are talking about is a very recent release from Blizzard, Warcraft III Reforged, which is a remastering of Warcraft III that Blizzard actually released yesterday to some consternation around the internet. Apparently, the servers weren't working properly or there are other issues related to the game. Another person that we're not highlighting right here actually tweeted to me and said, hey, is this false advertising because some downgrades happened with respect to the game. I'm not covering that in this video so much, except to kind of reiterate things that we've said in Virtual Legality before, which is that it's very difficult to show false advertising in software development, especially when these companies have little disclaimers on the bottom that say, this is not final footage, this is not the final thing that we are showing, and generally they put out tweets and developer updates that show exactly what they are removing. So in the case of Warcraft III Reforged, where they removed some of the cinematic elements that they had kind of advertised the game at in 2018. Probably not false advertising. Potentially you could bring a claim. Certainly if you want to, you can go and ask for a refund and see exactly whether or not that gets you one out of Blizzard or wherever else you may have purchased the game from. But in general, the Federal Trade Commission and the other various U.S. agencies are not going to be that interested in pursuing a claim for something like a $30 purchase when there are disclaimers that one could argue properly notified you of the potential for downgrades. No, instead of false advertising, we are going to talk about the end user license agreement because this was kind of highlighted on Reddit. You see here, I want to give the hat tip to Nicandros, who follows me and is a regular on commenting now on some of the live broadcasts we do on the channel and in the videos. And he said, Hoeg Law, some fresh virtual legality material. This time it's another end user license agreement confusion. And to me, this sounds like, hey, you agree that we won't be liable to get you attribution rights when we show your custom map in some custom map browser of ours, instead of we don't want another Dota 2 created without us getting a slice, which it is being portrayed as. Now, we're going to look at the actual language here, and we're going to look at this Reddit thread because I think it's useful to see how this is being framed in a very popular thread, which now has, as of the taping of this video, 2.4 thousand upvotes, has a lot of comments on it. And while I think this particular issue that is highlighted here maybe isn't that critical to the discussion, it also doesn't say that you don't have to assign your game rights. Adding on to that, as I found looking at the Internet Wayback Machine and looking at the previous version of this custom game acceptable use policy that Blizzard had done before their most recent update, you'd already been assigning all your modding rights to these games. So there's a lot to unpack here. So let's start with just this Reddit thread. Warcraft III Reforged Terms of Service requires handover of the moral rights to any custom map. Now, I want to stop right there. The very first thing that pops up is that this is not limited to Warcraft III Reforged. We're going to look at the documents in the universe of how they kind of interact on the Blizzard legal side of things. But the custom game acceptable use policy would appear to apply to all custom games that one makes in the Blizzard universe. This custom game acceptable use policy is pretty new as of the current iteration. I think it was updated about a week ago, and maybe that's not how people have been operating prior to now, but there is certainly nothing that would appear in that document to limit it solely to Warcraft III Reforged. So we're not actually talking about the Warcraft III Terms of Service as much as we are talking about Blizzard's new approach to how they're going to describe the rights that you give them when you make a mod off of one of their games. Continuing with this original poster on the thread. In the new TOS supplied by Blizzard with the release of Warcraft III Reforged, there's this little tidbit. To the extent you are prohibited from transferring or assigning your moral rights to Blizzard by applicable laws, to the utmost extent legally permitted, you waive any moral rights or similar rights you may have in all such custom games without any remuneration. Lawyers, right? A lot of good stuff there. I love remuneration. That's just a quality word. This thread continues by trying to explain that language as not only must you hand over the intellectual property of any content created within or for the game, but if local law prevents it, you must assign your moral rights to Blizzard. Now, they bracketed assign because you won't see assign up there because it doesn't actually talk about assignment. It talks about waiver of your personal rights. And that's a distinction in the law, right? When you assign something, that means you have a right and you hand it over to the other person. When you have a right and you waive it, that means you no longer can bring a claim about that particular right, but it doesn't mean that the other party has it now. So you can't actually assign your moral rights in this particular way if it's not legally permitted. And we're going to talk about what all this language does. But then this thread finishes off with, this is terribly anti-consumer. Prospective map makers and designers, this game is probably not worth the effort required. What happened to the newfound land of modding? Now, whether or not it's anti-consumer is probably an open question, but in order to get to that question, we kind of have to dissect what this actual agreement does, and then we have to talk about what moral rights are, because moral rights sound really problematic, right? Really terrible. You hear about moral, and you think, okay, that's a good. That's the connotation there is that's something good, and if you have to waive your moral rights, they're asking something draconian or something bad or evil of you. And what I want to talk about is that's not really the case. Moral rights are actually a bit ephemeral. They're not as specifically expressed in the U.S. law, especially as the direct bundle of rights we talk about as associated with copyright. And that's one of the reasons you're going to see exactly what this language does, which is, yes, significantly more what I would say belt and suspenders oriented than the language they used in their previous version, which we're going to look at the end of this video. And when I say belt and suspenders, I just mean essentially multiple ways of getting at the same point. Because this first paragraph is where this language was found. You see here, this is the custom game acceptable use policy of Blizzard. You see it is last updated January 21st, 2020. And in a bit of a legal no-no, they don't actually reference back to the older version of this document or anything else that might have covered these kinds of concepts, which I, of course, don't like. It is unusual in terms of these kind of big companies. Usually they are good enough to kind of refer back to their old terms and conditions. If you go look at previous episodes of Virtual Legality where we talked about EULAs, you will see us clicking on the little button at the bottom or at the top that says, show me the previous version, sometimes multiple times to kind of get a comparison point for what exactly happened here in this change. And the ownership paragraph did change, and we're going to talk about that as kind of the fulsome look at this in the video. But the main paragraph here is ownership. Custom games are and shall remain the sole and exclusive property of Blizzard. So that's, we'd like to take these apart by sentence, right? When you make a custom game, and we have to go and actually find that definition in the Blizzard end user license agreement, it says this document sets forth the design and development rules for custom games as defined in the full EULA, which we'll look at in just a second. But when you make one, they are the exclusive property of Blizzard. That's kind of the fundamental, foundational thing that you are agreeing on, is that this game belongs to Blizzard when you make it. You make a mod of Warcraft III Reforged or anything else in the Blizzard ecosystem, and that belongs to Blizzard. Without limiting the foregoing, without changing that sentence, okay, what you made belongs to us. You hereby assign, that's your operative verb, to Blizzard all of your rights, title, and interest in and to all custom games, including but not limited to any copyrights in the content of any custom games. So we've got two sentences that work together now. We've got everything you make is ours. That's just our blanket statement. And then without kind of limiting the blanket statement, if you need to assign something to us under the law, if the law is kind of a third party, the court system, the government, the USPTO, whoever it might be, Copyright Office, if they would look at it and say, well, actually, that belongs to that modder over there, you agree to assign everything to us. It's not just ours de facto. You also have agreed to operationally assign those rights to us. And then continuing on with the protective, here's the suspenders for your belt. If for any reason you are prevented or restricted from assigning any rights in the custom games to Blizzard, so you've said it's ours, you've said you'll assign us the rights. If for any reason the law or otherwise prevents you from doing that, you grant to Blizzard an exclusive, that would be exclusive to you, so you can't use it anymore, perpetual, worldwide, unconditional, royalty-free, irrevocable license enabling Blizzard to fully exploit the custom games or any component thereof for any purpose and in any manner whatsoever. So, the broad concept here is custom games are Blizzard's. You agree to assign anything that would be involved in a custom game to Blizzard. If something prevents you from doing that, then you agree to license all the rights that you still own, but you agree to license them to Blizzard on an exclusive basis. If you've previously been in Virtual Legality, you know that an exclusive license to intellectual property is very akin to a sale. Since it's exclusive, it means you no longer have the right to use those bundle of rights that we talk about in the Copyright Act. So this is essentially 3 ways of saying the same thing. Custom games are Blizzard's. You further agree that should Blizzard decide that it is necessary, you will execute any future assignments and or related documents promptly upon receiving such a request from Blizzard in order to effectuate the intent of this paragraph. That's your final bullet, right? If one of the government agencies, if someone else in some other jurisdiction winds up asking for us for proof that this happened, you agree that we can draft up a copyright assignment, a formal document of some kind, you will sign it, and you can agree to submit it to whoever requires it in order to prove that these custom games belong to Blizzard. You've agreed to all those things. That's the full bundle there. Now we get to the language that was actually highlighted in the Reddit paragraph. But you can see one of the reasons I wanted to actually have this video is that's the super important part. That's the part that people, if they are upset about modding no longer being supported properly by Blizzard, that you can't have the Dotas of the world pop out of this ecosystem anymore, that's where the ire should be focused. It's on the opening half of this paragraph, not this second half. But that is what was actually highlighted in the Reddit. That is what has the 2.4 thousand upvotes. That was what was highlighted to me in my Twitter, so I want to talk about it a little bit. To the extent you are prohibited from transferring or assigning your moral rights to Blizzard by applicable laws, to the utmost extent legally permitted, you waive any moral rights or similar rights you may have in all such custom games without any remuneration. That's the sentence we read on Reddit. So moral rights are a subset of the rights in the game, right? So ownership says all parts of this game are ours. You assign it to us, you will license it to us. If you can't assign it to us, you'll sign any documents that are necessary. And if some piece of the law says you're not allowed to assign your moral rights, and we'll talk about what those are in just a second. If some piece of the law says you can't assign them, then you waive them for yourself. You don't have the same language up above in the opening parts of this paragraph where you assign them to us, because it's not allowed under law. It's not allowed to really license them if they're not allowed to be assigned. So they don't say that. They don't say you license it. They say you waive them, and we don't have to pay you for that waiver. Without limiting Blizzard's rights or ownership in the custom games, Blizzard reserves the right in its sole and absolute discretion to remove custom games from its systems and or require that a custom game developer cease any and all development and distribution of a custom game. Please note that your Blizzard account can be subject to disciplinary action in the event that you do not comply with Blizzard's request or this policy. That's ownership. And that broadly, in very many words, right? Lawyers get paid by the hour. We put a lot of words down to say some simple stuff. That broadly says when you mod something, when you make it in our ecosystem, it is Blizzard's. You'll do all this other stuff to evidence that it is Blizzard's. And if you aren't permitted to assign what we're going to call moral rights, which we'll talk about, then you waive them for yourself. And that would give Blizzard a full assortment of the rights associated with the custom game. This is probably the broadest, most loquacious, verbose way of saying all of that. You can also have just said the first sentence and probably been fine. But this is the very legalistic, very risk-averse way of writing these kinds of concepts. The rest of this acceptable use policy is pretty interesting. We're going to see that it's mostly mirrored in the acceptable use policy that they had previous in the year. Custom games have to be playable by all users. Your use of third-party content in games, this is interesting. This might be another video later on if it ever comes up. But this is basically promising that you won't put Star Wars characters in your Warcraft 3 mod and things of that nature. I suspect there are a lot of violations on the service right now of this particular provision. For the most part, as we've talked about in Virtual Legality, it depends on how popular these things get, whether Blizzard notices, whether the intellectual property rights holder notices. But this provision gives them the right to say, hey, you're breaching paragraph 3 if they need to remove it. If Disney comes and complains about the Star Wars mod, they can say, yeah, you're in breach of paragraph 3, so we can remove it. Commercial exploitation of custom games, unless otherwise authorized by Blizzard in writing. In other words, unless we waive this paragraph, custom game developers cannot develop custom games for profit. And then as a kind of combo deal with that, you see paragraph 6. You are allowed to accept donations for the development itself, but not to sell the product, which is an interesting way to kind of try to slice that onion. I think it's interesting that Blizzard's trying to accomplish that, to essentially encourage modding, because, of course, due to paragraph 1, you get those donations, you develop a really successful custom game. Hey, it's Blizzard's, and you really can't fight about it that much with this language out there in the world. And then just to kind of concept this, I said that we would talk about what a custom game is. They incorporate the end user license agreement, and we can see here the definition of custom game. This is midway through their current end user license agreement. It says certain games include editing software that will allow you to create custom games, levels, maps, and scenarios or other content. For purposes of this agreement and any agreements referenced herein, custom games include all content created using the game editors, including but not limited to all digital files associated with such custom games, as well as all content contained within such files, all titles, trademarks, trade names, character names, or other names and phrases associated with or included with the custom game, and any other intellectual property rights contained within the custom game, including any and all content, game concepts, methods, or ideas. The manner in which custom games can be used or exploited is set forth in the custom game acceptable use policy, the terms of which are incorporated into this agreement by this reference. Now, that language is actually probably a little bit too broad. It would be difficult for Blizzard to really come and fight you if you otherwise used an idea from a game that you modded into Warcraft 3 in another manner. It would be difficult for them to come after you. Of course, we've talked about large chip stacks at the table, and certainly companies that have a lot of money making your life very difficult in litigation. So it's not a great thing that they kind of claim all those rights and ways to prevent you from using them outside of the Blizzard ecosystem, but they would have difficulty doing it. Now, to talk about moral rights, I wanted to actually bring up the Copyright Office's discussion of this, because I think that's where people are getting a little bit tripped up. So as we said earlier in the video, moral rights sound like something good, and they are, but asking you to waive them isn't the end of the world. It's very standard in the documents that I write, especially for software development. And it basically comes down to this. Now, this is the overview of a report that we're actually going to look at in a little bit more depth that the Copyright Office put together. It says here, the U.S. Copyright Office has completed its comprehensive study of attribution and integrity rights in the United States. The term moral rights comes from the French phrase droit moral. Hopefully I got that right. Please leave a comment to this video if I got that horribly wrong. And generally refers to certain non-economic rights that are considered personal to an author. Backing up a step, moral rights are rights about attribution. They come from a notion that when you are having an expressive work created, whether that's a song or a book or a movie or a piece of art in a museum, that the author is personal to that piece of art. So moral rights kind of sprang up to say, you have the right to associate or disassociate your name from that work that you created. And to such same extent as that might apply, you have certain rights to prevent that work from being adulterated, from being changed in a way where if your name were associated with it, you would no longer be happy with that. Think of directors that make movies that sometimes have the production house, have the studio, have the editor come in, change it so much that they no longer want their name associated with the project. They actually go by the name Alan Smithy for all these movies that the director no longer wants to view as associated with their work output because there have been too many changes. There's been too much outside interference with the actual project. That's really kind of the concept of moral rights, that you should have these rights to associate or disassociate your name and protect the integrity of the art that you have created. But as you can kind of tell from just that description, the main issue here is that they aren't terribly expressed very well in the law, especially in the United States. They're somewhat European concepts. And so the United States actually has gone and looked at this very significantly. This actual report that we saw is actually very recent. It's April 2019. As you know, if you follow Virtual Legality, a lot of these reports are not that recent. But also, we don't necessarily want to read, what do we got here? 140 pages of this report. We can kind of get the concepting a little bit easier by just kind of scanning through and looking at what is happening here. So basically, we've got the executive summary of this report. This is talking about the landscape of moral rights protection in the United States. And you see here the sentence in the middle of the page, the landscape of moral rights in the United States is complex. I would hope so for a 140-page report, but hey, the basics of this all, and I will link this in the description of the video as I always do if you are so inclined to read a 140-page report from the U.S. Copyright Office. But the basics here are that those moral rights, attribution, and integrity that the United States is obligated to protect through a convention called the Berne Convention are protected kind of ancillarily through the existence of other laws. see here a reference to the Lanham Act, which basically prevents people from passing off others' work as their own. You see reference to a Visual Artists' Right Act, which actually focuses this on works of visual art. So you have a little bit more protection if you're talking about specifically works of visual art versus other works in the United States. You see here references to these other laws. But the overall concept is not one that is terribly well articulated or really kind of emphasized in U.S. law. It's really emphasized more in European law. And you'll see that if you go and you read all this history of moral rights. One of the issues in the United States is basically whether or not moral rights as a concept compete with our notions of copyright and other things that are already existent in U.S. law. So we see here in this section, the moral rights patchwork, exactly how we protect it, the treaties that we've entered into, and then the guiding principles for review of our regime, which is what I wanted to highlight, just to kind of highlight exactly what the U.S. is dealing with. So you see here, Section 1, moral rights in the First Amendment. If you really think about it, not being able to say something about a specific work is potentially a problem under the First Amendment. Similarly, moral rights and fair use say, hey, do I have to attribute things in a certain way if I'm otherwise protected under the fair use of copyright? And so there are these conflict points in the U.S. and under United States law that come up that are currently and always really being evaluated by the various agencies of the United States. Copyright term limits, all this other stuff that pops up because you've got things coming out of copyright. One of the big cases here that you can read about in this report is essentially a third-party video retailer taking a piece of film footage from a series that Fox had done, I think back in the 40s, and changing it over, adding a new intro, changing the name, and putting it out there, and whether or not that was a violation of what amounts to Fox's moral rights. And the Supreme Court ultimately determining that probably not, that what was happening here was that the Lanham Act, the trademark protections, all that other stuff about misappropriating works doesn't apply to the underlying video footage in something like that. It applies to the product as presented. So the name change and everything else meant that they could put it out there into the marketplace. And that's kind of the state of the U.S. moral rights law. It's not something that is really ultra significant because of that non-economic concepting. And it's not something that the United States has focused on. I suspect if you're in a different jurisdiction, I know we have viewers of Virtual Legality that live in Europe, that live in other places, that it's probably stronger in the European Union conventions and things along those lines, and that Blizzard needs to be aware of those. There are certainly jurisdictions in the world that say, for instance, you can't assign your moral rights. Because what is a moral right? It says, hey, Rick Hoeg made this thing. And if you were to assign it to Blizzard, Blizzard could say, Blizzard made this thing. And so when we go back to that language that they propose, they say, hey, if a law prohibits you from assigning your moral right, you hereby waive it. You can't come in later and say Rick Hoeg made this thing. We can't necessarily say Blizzard made this thing, but you can't come in and confuse the issue at a later point in time. That's the language that was added to their contract, and it isn't as significant as the assignment language. Finally, I wanted to finish up this video with what I could find of this custom game acceptable use policy from prior last year. So I went in the Internet Archive Wayback Machine looking to see whether this had been covered before. There are only 2 captures from the middle of 2019. This one is actually from October 9th. But you can see here this custom game acceptable use policy, which I suspect maybe was added on pretty recently to the way they concept out their end user license agreement. You can see here it doesn't have that ownership paragraph to start. It's actually in paragraph 3. But you can see other concepts that were included in this earlier version of the game, of the custom game acceptable use policy. Custom games should be playable by all users. That matches up. Copying Blizzard games, that's a new provision, or actually an old provision that would appear to no longer apply. It says custom game developers may only recreate the following Blizzard games. It has a list of Blizzard games. And for the avoidance of doubt, StarCraft does not include StarCraft 2, although custom game developers may use StarCraft 2 assets to create maps and mods. Custom game developers are not allowed to recreate single-player missions. So there's a little bit more strenuous, specific rules about what you can do with StarCraft 2 versus some of their old legacy games. Now, that provision actually came out of the custom game acceptable use policy, so there's an open question about whether or what is controlling what you can recreate in the Blizzard universe. Maybe they took away all of the ability to recreate their existing games. That would certainly be a possibility. Or maybe you have a more broad authority to recreate their games. partly it's going to depend on how Blizzard interprets what they did here and whether or not they want to make trouble for some of their modding community. Obviously, based on the Reddit thread, based on what I've seen in my social media, based on the Blizzard of backlash, there are a number of folks that don't have a lot of faith that Blizzard will be welcoming and helpful towards the modding community, but I think that leaves an open question. In the ownership paragraph, you've got the main crux of what is in the ownership paragraph right now. Custom games are and shall remain the sole and exclusive property of Blizzard. End. Done. When you mod it, it's Blizzard's. Without limiting the foregoing, you assign. Additionally, Blizzard shall have the right to maintain the custom game on Blizzard's arcade service, even if the developer of the custom game requests that Blizzard remove the custom game from the arcade service. That sentence doesn't appear in the ownership paragraph anymore, so it's unclear exactly how that operates. Also, it's worth noting a number of these provisions could be moved around to the various kind of legal documents in the Blizzard legal document ecosystem, so some of these might be covered elsewhere. Certainly when setting up a virtual legality, I don't have the time to go through every word in every piece of legal documentation for Blizzard. So if you see this kind of reference to arcade somewhere else, you can let me know in the comments to this video. Finally, we have use of third-party content in custom games, which matches up, commercial exploitation, which matches up, incorporation of the end-user license agreement, which matches up, and donations for custom game development, which matches up. So ownership got buffed, if you will, to use the parlance of these games, and the copying Blizzard games section got removed to leave you with the 6 paragraphs that we saw in the first instance. But going back to the Reddit thread, the most important part is, at least as of June of last year, this ownership provision for custom game acceptable use was always in there, was always in the Blizzard document. So that happened a while ago. That applies to all the Blizzard games, not just Warcraft III Reforged. And the moral rights is kind of a red herring. That, yeah, that's important. I can certainly understand why people who make a mod would at least want to have their name associated with it so that they could potentially sell their experience to a third party based on the fact that they made mod X that turned out to be very popular. But it isn't quite the same thing as the economic rights, the copyright, the right to exclusively distribute and to sell that you are already giving up to Blizzard in the main paragraph right now. Absolutely, if you're upset about that, let Blizzard know. But that didn't change just from the addition of the moral rights language, so I wanted to add that clarity if I could. This has been Virtual Legality for today. If you like this, please like, please subscribe, please share it around with anybody that you think might be interested. Please add it to that Reddit thread if you think the folks on that Reddit thread might otherwise be interested in it, or just add it to games in general. Otherwise, if you caught this on YouTube, thank you so much for watching. I very much appreciate it. And if you listen to it in its podcast form, thank you so much for listening. And I will catch you on the very next episode of Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.